Thank you again for being here. I want to especially thank our presenter, Gayani Weerasinghe. Close. I know it's not exactly right. I'm trying on the name, But thank you so much, Gayani, for being here. I'm so grateful for your support, for your help, and for your collaboration here at the Rec Innovation Lab. We're so grateful for all of the help that you've giving and are continuing to give. And Gayani, for those of you who don't know, she just we recently became connected, and she is an entrepreneur herself. She's a lawyer. She's a number of other things. I mean, she's one of the most talented people that I've ever met, and like so many entrepreneurs, just constantly going. And she's still willing to take her time and to help other entrepreneurs to succeed. And she knows a lot about intellectual property protection, more than I do about patents and copyrights and all of the all of the other issues that I constantly get questions on. So now we have an expert who can really help you find the right resources and find the right way to go. So with that said, if you have any questions, we'll get started here now. I think we're pretty much ready to go. But if you do have questions while we're going, please let us know. You can put them in the chat. We have Brenna and Emma today are helping to facilitate, and they'll watch that chat and let us know if there is anything in there for us. And anything I'm missing, I think we're probably good. I think I'll just pass it on to Gayani so she can introduce herself and tell you a little bit more about what's in store.
Hi everyone. Thank you, Tanya. It was a pleasure to connect with you. I think Professor Muthi at San Marcos is the
CSUSM.
CSUSM connected us. So I actually gave a 3-hour lecture on this subject for his class, a master class for biotech entrepreneurs. So I shrank this for the time fitting. So obviously this is a subject that is very complicated, intellectual property, because it covers patents, trademarks, copyright, trade secrets, trade dress, and then how that is interrelated, and that's how it is related to also business aspect of it. And I'm very excited to talk to the entrepreneurs about this subject, because I think once you kind of understand how all of these work together, can really help you when you're starting your business or running your business, because lot more people are becoming aware of the value of IP, and also could be costly if you don't know this. So with that, I will share a little bit of background about me, not to chat a long time about it, but I've been an attorney now for 6 years. I was a scientist before I became an attorney. So I have I was actually doing a PhD program at Johns Hopkins. I have a terminal master's from them because I didn't finish my thesis project and decided to come to San Diego to go to law school. So I went to law school locally at Cal Weston, which is downtown. And while at law school, I did a whole bunch of internships, including at Pfizer, pharmaceuticals, and I have worked for 3 different judges, including federal judge, a couple of federal courts. And I also have worked with a couple of law firms. And then after graduation, I went to in-house at Sorrento Therapeutics, which is a public biopharma, where I was the right hand to their general counsel. And we put into a lot of things in place. So I was there for a while, short while. It's not that long, because there was a merger acquisition, and I got laid off in the merger acquisition, but they came as my client to the big firm I went to afterwards, where I did intellectual property, and I didn't like the setting there. So I actually left that job and went to a smaller firm where I also did patent prosecution, trademark prosecution, and business law related matters. So, and then last year, I was laid off because there was a merger acquisition that affected one of our clients, one of our main clients. So as a small firm, you only could have so many. So I got laid off in that, and I decided to launch my own practice. So I have my own law offices now for over a year, and I also have a YouTube channel called Inventive Mind. You have some links to it, I believe, in the chat that I put in there. So you could take a look at those, and that's to kind of help the creatives and entrepreneurs out there. So, you know, if you have any questions, let me know as I go through this, because like I said, this is a complicated subject. So it's going to be very superficial overview right now, but, you know, I absolutely would welcome questions where you think I didn't convey something properly or something. So with it, like anything as any attorney does, I do have to go through the, and my screen share have stopped sharing. So I'm gonna go back in. Give me a sec.
That's no worries whatsoever. This happens from time to time. This happens from time.
Yeah, I think it's because I had it out for a while and it's just kind of does this. Okay.
Does that, yeah. And so I'm going to ask the audience, if you are just coming in, please make sure to, excuse me, mute your microphone and turn your video off, so that we don't have too much of a bandwidth draw on this. And it looks like, oh good, looks like we can see it all good now. You're good to go.
Okay, so as with anything, as with any attorney, I had to give you my disclaimer. This is for educational purposes only. That if you have a specific question, please go see an attorney that works in this area. Meaning this, like if you're looking for IP advice, go see an IP attorney. If you're looking for business advice, go see a business attorney, because they don't always practice both. I have the pleasure of practicing both because I have quite a bit of internships, and my background lend me to this topic. So, and I am a patent attorney. So I make a distinction for those who are thinking about law school, like Brennan mentioned to me. I don't know if I should have said that. I'm licensed in California, and I also have a patent bar. It's a different license. So you could only call yourself a patent attorney if you have the patent license. So I am a patent attorney. I have a separate license for it. Today's agenda, the introduction of the topics, and then I will kind of cover what I think might be the most important part right now is like when you're thinking about naming your business. And then if we have time, we will go to business contracts. I did tell Tanya that I will stay behind, and if anybody have any questions, we could go through that too. And I have shared, like I said, some couple of YouTube videos on these topics as well. So, you know, I would be remiss if I don't start the presentation about why and where our intellectual property comes from. Intellectual property have been a very important part for United States. One thing you have to keep in mind is intellectual property oftentimes, patents, trademarks, those are all national rights, meaning you have a trademark in US doesn't mean you have trademark rights in Canada or Europe. You do have to file separately in, you know, those different countries. And our trademark rights are coming from the Article 1, Section 8, Clause 8 in the Constitution. So that give us the right for the inventions. It's the limited times to authors and inventors, the exclusive right to their respective writings and discoveries. So that's how important intellectual property is for US. When you think of intellectual property, I'm a visual learner, so that's why I tend to use visuals. These are all sorts of intellectual property, and there's also subsets too that I'm not going to address due to time, like trade dress, which we can talk about at a different time. But we have patents, we have trademarks. You might see TM or R. TM and R, I will go into it when I get to trademarks, what's the difference, and sometimes you will see SM. Then you have the copyright symbol. And then, of course, you have our famous kind of marks, symbols, phrases. So the reason I'm starting with the copyright is, and I'm kind of walking it backward, is because patents are going to be more complicated, and I didn't want to kill the whole time on patents. So I'm going to start with the most easiest one to describe first and kind of walk our way through the presentation. So what is a copyright? Copyright is actually what they call a moral right. So by the way, I'm putting the writing here for your purposes. I know you could read faster than I could say it, so I'm not going to be repeating what's in the slides. I probably will point to some of it, but I may not repeat it, just so you know. So the copyrights is sometimes what they call a moral right. It's for anything that is creative, that is fixated on a tangible medium. So of course, you think about copyrights for videos, music, art, all of that is copyrights. And then also you could have a federal registration for copyrights, but there also is common law rights. Now you're going to hear that term common law rights in my presentation with trademarks also, and the difference is common law rights, meaning if you've been using it with your work, you have certain rights that are coming from like case law, and is actually, even if you haven't registered the copyright, you have certain rights that you can enforce. But they are limited rights versus if you actually have registered a copyright. And for like to sue somebody to bring a copyright infringement, you do need to have registered it, but there are limited rights with the copyright, just having the symbol. And as you can see on the bottom of my slide, I have my copyright disclaimer, the copyright notice on there, not the disclaimer, the notice that says copyright 2020, that indicates the origination date of the copyright, the timing. That's why you see 2018, 2019, those whenever you created your work, who owns the right. So you want to put your name or your business name, and you could put all rights reserved. It's what you call a constructive notice to others, what this is. And so what this also means is if you see something like this and you want to share this slide with somebody else, you had to get the permission from the person who created it before you share it. And it's, I think, you know, a lot of people don't think about this. They will take a textbook and photocopy it when they used to do it. I don't think you do it that much anymore. You might screenshot it and share it with a friend. Well, that's actually considered copyright infringement because you are not usually, it's a one user license, meaning if you buy a PDF copy or something, you only have the right for one user and you cannot really be forwarding that to other people. And so let's see, this is a little tricky because I just want to make sure I covered what I have in here. So the copyright terms are a little bit specific, and so there's a 75-year term from the author's life, and then there is a 125-year term. So they last a lot of different times, and you will hear music, for instance, that you cannot use on like YouTube because they are copyrighted material. Now, I didn't have time to put this into the presentation because I'm going to move kind of fast on this. But if you want to use certain images or music, you could actually get a Creative Commons license that is basically a place that provides licensing for you to use it in a more broader way. Now there is something called, that's also not in this presentation, is called fair use that you will hear. Fair use actually says that you could use a copyrighted material for a limited purpose that is, you know, on a limited base. So let's say you want to critique a movie, like you see film theory on YouTube. What they're doing is, because they are critiquing it and they're only using small portions of the film, they are using that under fair use for educational, informational purposes. But you always want to be very careful when you use that in that context, because it's could be a defense that you're asserting, but it depends. There's a factors that goes into infringement cases. So let's say you're using like 40–50% of the content, you now might be outside of the fair use. So less you use, the more original content that you put out, the better. And it's something you want to be careful when you're using copywritten material. And let's see, and this circle gives reasonable notice. So now the second topic is trademarks. What is a trademark? Trademark is what protects the goodwill. It's goodwill of your business. Your name, it could be a name, a phrase, a slogan, or design. And what trademark does is it gives a source of the material. So let's say you go to the mall and you buy something from Kate Spade. That Kate Spade name is trademark. So what it does is a recognition of that, the designs and what the business have built into it, the material, the creativity, how good it is, all of that. That is what a trademark protects. Again, going back to copyrights protect your original creative ideas that you're fixating on a tangible medium. Trademarks protects the source of goodwill you put into your business. So this is why it's important to understand the different aspect of these different IP. So TM is something you could put on, like let's say you are starting your business, you have a website. You could actually start using TM next to the name of your business, because it's give others the notice, just like the copyright symbol that you should be using on the bottom of your website, and how you see all rights reserved. You should be using TM next to anything that you're planning to trademark, like your logo, your name of your business, because what it does is give constructive notice to others that you either have filed for a trademark or will file for trademark. You can use the TM, but you should never use the R, the registered R, unless you have a registration, because if you misuse it, you actually could be barred from getting a trademark. But you should be using TM. So, what you want to know is what a SM and a TM difference is. So there's goods and services. So trademarks covers the goods, and the SM covers service marks. And it's kind of been used interchangeably, but you will see both. So let's see. I'm just making sure that, and I'm giving the legal definition here for your purposes. And yeah, we are done with the trademark part. Just the other thing I wanted you to know about trademarks is trademark process will take about at least a year to get. So about 6 months to a year. So when you go through filing the trademark, usually if you're working with the attorney, they will do the clearance for your trademark, and they advise you on the classes. Like I said, there's 45 classes of goods and services for trademarks. 35 of those are goods. Like let's say you have a business that you have, t-shirts, and you're also making bags. Those are two different classes usually. And if your services, let's say your service base, you're doing a consulting firm for businesses like SEO services, that's a service, so it's under a different class. But if you're doing educational training seminars, that's a different class for trademark is called, I think it's class 41. So what an attorney does is, and this is where you want to be careful as entrepreneurs, if you go file it yourself, you may not write the claims properly, because the trademarks, there's a claims that you put in that you're saying what your business does. Those can be written in a more broader way, or it could be written like, when you look at a trademark, sometimes people have several trademarks for the same reason. That's because they may have filed by themselves at first and they didn't cover everything that the business was trying to do. So they can have to file a second application or third application. Trademarks are always a one-way street with United States Patent and Trademark Office, meaning once you file an application, you cannot broaden it. You could, so each class is about $275 for filing. And usually when you file, you will file for about 2-3 classes sometimes. It's non-refundable. And if you got the claims wrong, if it's done improperly, then you have to abandon that application and file a new one if you cannot save it. So that's one thing to keep in mind. With patents, like I said, I'm just kind of zooming through all these topics, and I know it's a complicated topic, so I do suggest that I do have videos online on my YouTube channel for each of these topics I'm discussing, so you could take a look at it if you want to refresh your memory. So what a patent does is it's a right, exclusive right given by the United States Patent and Trademark Office for somebody who have invented something. So you cannot patent an idea, but you can, what is exist in nature, but you, on the other hand, you could patent something that you invent, like meaning you don't have to have a prototype to get a patent. Long as you have all the elements of the invention down in a design, let's say you're creating a new chair and you have all the design put together. If you know all the elements of it, that's called constructive reduction to practice, and you could actually file for a patent. So when you go here, the patents, like I said, is a national right. So just because you get a patent in US doesn't mean you have patent rights in Mexico, in China. So when you're doing a patent, it's really important that there are certain restrictions for US and other countries. For instance, if you had presented it if you sold it online, if you have an invention, you start selling it, you cannot get a patent because you had done a public disclosure. With patents, you had to basically proceed with secrecy at first before you file the application. Once you file the application, you have more leeway and you could say patent pending, but it's very important, even if you present to investors without an NDA, you could be considered public disclosure. And you could that could block you from getting a patent. So it's very important to know that patent rights are very exclusive rights. They are actually an exchange between the government and the public. Basically, government is giving you 20 years of exclusive rights to prevent others from making, using, selling, or distributing your invention. Because you have to publicly disclose what it is. So for instance, you will hear with Elon Musk and Tesla, at some point he said he's not going to enforce the Tesla patents, what that means is he have the patents and he have already filed the patents and it's all public information, but he will not sue others who are trying to create these electric batteries and the cars that are coming from Tesla technology. Basically putting it as a public disclosure. But if somebody have a patent and it is public information, if you get that information and you start using some of it to build something else, you could be infringing the patent rights. When you look at a patent, what's in a patent, what you want to do is, it's a description of your invention, but what you're really looking for is what's in the claims. Claims are basically like the title deed to your property. It defines patent application. If you look at some of these patent applications, I work in pharmaceutical industry, so our patent applications were like 200-300 pages. It's a lot of information. But the claims are the most valuable part. The application specification, they call it, description could be covering everything from A to C, but the only claims are to A, B, and C. So that's why it's important to look at the claims, because the claims will tell you where you could be in trouble and where you could actually, they're not covering the patent. So that's usually called freedom to operate. Search is FTO. A lot of companies, before they go into an area like an established company like Pfizer, would do a FTO searches before they even start certain projects, because they want to make sure how much leeway they have, what do they have to worry about, you know. So these companies will take a look at it, and they may have to in-license certain technology before they start working on something. So what can you patent? We kind of cover this. So it's something new and useful, a process, machine, manufacturer, composition, and improvements. So let's say you have, you know, everybody know aspirin. It's already expired patent because it's been out there for 20+ years. You get the exclusive patent rights from before 1995. It used to be either from the issuance date or from the date of filing. But now, after 1995, it's from the date of filing your utility application. I will circle back to that term in a second, but what I want you to know is, if you invent, let's say, a new treatment with aspirin, nothing for headaches, but let's say you figure out that it helps with some other, you know, disease treatment therapeutic, you could actually patent for that purpose. But of course, now there's also the other issues, like if, for instance, aspirin was under patent protection, you will have got, even though you have the improved process patent application, you cannot still use it without getting the license from aspirin Bayer makers, without using getting their license. So what that means is, let's say you for like cell phones, for instance, if you actually been using these cell phones, they have like, I don't know, like probably like 20+ patents or 200+ patents in them, because the electronic chips, each one of them have patent, any kind of a camera, all of that have multiple patents. What a patent right gives you is the right to prevent others from making, using, selling, distributing. It doesn't give you an affirmative rights to do something, meaning just because you got a patent on like a 3D gun doesn't mean you could produce it now and sell it. You could just prevent others from doing the same thing that is covered in your claims. So I hope that makes some sense. If it's confusing, please let me know if there's any questions, because it's kind of hard. Since I don't see your faces, I can't even tell if anybody's looking confused. So also the patent terminology, you will hear there's provisional patents and there's utility patents, and you will hear PCT applications. The difference, provisional patent is a placeholder. There's no actually a provisional patent. It's a provisional application. So provisional application is the placeholder application you could file as long as you have some information about your invention. And usually inventors who are used to patenting stuff will file early to get that date, because remember, we have America Invents Act that went into effect in 2013. And that basically said is the first inventor to file had the first rights, like first in time kind of idea. So you want to file early before, let's say, somebody else filed for something similar. And there's technicalities I wouldn't go into, but basically, let's say you have two inventors who came up independently of the same invention. If inventor A and inventor B, and inventor B filed before inventor A, now inventor B has the first rights, and they now they could bar you from getting inventor A cannot get the patent because that other inventor B have filed first. So that's why you file early. But what it does is a provisional patent is a placeholder, meaning it doesn't have to have claims. It doesn't get examined. It's only give you 12 months, and then you must file the PCT application, which is the basically the international application, or you have to file your utility application, which is basically filing in just US. Now, if you file the PCT application, you actually get 30 months to enter. It's a treaty, it's under a treaty, and you have 30 months to enter into other countries like Japan, China, some places in Europe, like basically about 146 plus countries are part of that treaty that allows you to enter into those countries at those within that 30-month timeline. I think there may be a couple of places that say 28 months, but it just give you more time. If you're just planning to file in US, then you file the utility in US, and it will call a utility application. And those are the terminology that you want to be watching out for. And once you file a provisional application, you could actually say your patent pending technically. So that's the other reason why some people file. Okay, the interest of time, I'm just going to kind of go through that. Just inventorship is very important for US. So, and I put this slide in here for you to know what that means. Inventors, you know, they must have come up with the invention, and reduction to practice can be actual or constructive, I had mentioned. But if you hire somebody else to make the prototype you already have came up with, they are not going to be an inventor. So that's why it's important to know who's an inventor. Let's say you come up with the chair analogy, and your friend says, oh, you know, that like the back of the chair will work better if you use this material. Now, even though you came up with 90% of the design for the chair, and your friend just made that tiny tweak, but it's part of your invention, let's say they contributed 10% for the overall invention, they is still considered part of the inventorship analysis. They are inventor. So in that case, what's the challenge is if you go ahead, file the patent without including your friend who contributed that tidbit to the end, you could actually put your whole patent at risk by having the wrong inventorship, because if they could come back and say, hey, this inventorship is wrong, I contributed this part, and they had to, of course, show evidence and all of that, but eventually invalidate the patent, because if your inventorship of the patent is wrong, it's a way to invalidate a patent. So that's what sometimes the patent litigation attorneys do when you get sued for you know, patent infringement. Other people, the litigation attorneys, will be looking at those kind of things, how to break that. So they could say that he's not a valid patent to begin with. So that's, as entrepreneurs, you want to be aware of these kind of things, because that could actually affect your overall business if it's like a key patent for your business. So there's a little more over there. And then we get to trade secrets. So you hear trade secrets. Trade secrets are basically what it implies. It's something you could keep as a secret. Or usually if you don't want to patent it, because when you patent something, you do have to do a public disclosure, full disclosure. You could actually use trade secrets if it's not something that could be easily reverse engineered. Reason is, if it's something that could be reasonably reverse engineered, if somebody reverse engineered it, then you have no way to like block them. So usually if it's something can be reverse engineered easily, then you probably want to file for patent, because you at least get the 20-year term of the exclusivity. So, you know, with what can be protected, it can be information, formulas, patent compilation programs. So entrepreneurs like you, if you have a business consulting practice, for instance, if you have a program, how you do business development methods, those can be protected as a trade secret. But whenever you have a trade secret for your company, it's important to keep in mind, with trade secrets, you have to have policies in place too. So you can't just claim that's a trade secret. You have to have, you know, contract like confidentiality agreements with your employees. You have to limit who have access to the information. You have to let them know this is a trade secret, that you have to actually function as you're protecting a secret. It cannot be an afterthought. But there are ways to, if you have an employee and they got access to their trade secrets and they go ahead, leave that company and build their own company, there could be you know, actual proprietary information issues where one employee take that information into a second company. That called misappropriation, and you have civil and criminal discourse to go after those. But again, it's important to know what you have and what policies you have in place, including policies within your employment contracts with your consultants or employees that, you know, you do have trade secrets. So you basically had to let them know, and you had to protect it like a secret. You cannot have everybody have access to it and make it a secret. So this is just a summary chart that I think will be really helpful for everybody, that of all these topics. Basically what I mentioned before, there's the utility patents, there's design patents. Those are ornamental design. So basically like a cell phone with like Apple, if they have the structure of it and where the thumbprint, the fingerprint, that could be part of the design patent. While what's in here is a utility patent. There's plant patents, there's trade secrets, there are trademarks and copyrights. And it's also go over those terms, length of these, and then give you some examples for you to think of. So trademarks for naming your business. I think we have about 6 minutes. So here's a video I have on my YouTube channel. And it's, I think, under 4 minutes. Actually, I think it's 3 or 4 minutes. You want to think about naming your business and trademarks is because, let's say you name your business and it's confusingly similar to another business that is doing something similar, and they have a trademark rights, they could actually send you a cease and desist letter. So trademarks, unlike domain names or business names that you register with California State or in Delaware or wherever you are registering, could have issues, because when you're registering with the state, your business name, if it's not the exact name as some other business, they will allow the registration for your LLC or corporation. Or same thing with domain names. If you change one letter, one word, it will go through. But trademarks is not the same. Trademarks actually look at what services and goods and services your business provide. And is there another mark, somebody who's in the field who have a similar name, who you're trying to like basically derive their business, like get customers from the goodwill they have built by confusing the consumers. So what they're looking at is what a consumer will, you know, look at. So like, for instance, if you have Nike shoes, and you create a company called Nike with the NYKE, and you are producing something similar to maybe not even shoes, but like apparel, fitness apparel, well, actually Nike could still get a cease and desist against you for the violation, trademark infringement, because it's close enough that that the name sounds that you're trying to drive business. So I'm from Los Angeles. I'm a huge Laker fan. So the other day, when I was at Los Angeles, like a month ago, I saw this person who had named their car wash business. Like they had a label on back of their, like side of their van that say Laker Wash. And I was thinking, wow, that's a big problem. That could actually get them in trouble with the Laker organization, because what is could be implying is somehow what this car wash business, that the detailing business this person have, is somehow endorsed by Laker organization. Now, remember, there's 45 goods and service classes, but what it does is, even though it's like car wash, it's very different from what the organization stand for, Lakers. Because of how well known Laker organization is, that the impression that he's somehow linked to them can be a problem for them, and they will, if they actually know, they will send a cease and desist. So that's the kind of thing you want to think about. Okay. And sorry, I didn't mean to put that. I put the links in there. I wasn't sure if I will have enough time. So with the contracts, this is really important. So I'm just going to try to add this in the last 3 minutes we have. It's the IP in contracts. So a lot of times I hear people say, oh, it's standard contract, it's IP. They don't really think about it. And you also want to be careful if you have IP, intellectual property, not everybody actually understand IP. Not all business attorneys understand intellectual property, because they are very selective. They may say they understand, but they sometimes don't, because they do things that you're like, wow, they shouldn't have done that. So you want to be careful if you especially have intellectual property, because I remember a case where somebody created, let's say this, changing some facts on here. They have a business based on jewelry business on Etsy, and they have a business partnership, and they're creating a business partnership contract for the partners who are coming together to create this jewelry business. Well, attorneys who are just doing business contracts may put that together without including the creative rights, the trademarks, and other creative rights involved with this business, because there's creativity involved, right? So we had a case where I was at this firm. The business partners had drafted the contract, they finished that, and then they send it over to the IP department too. And we were like, well, the general partnership, the partnership agreement is already signed. It would have been better if the intellectual property was also included within that contract instead of as a side contract. So that's where you want to think about it. Where intellectual property provisions and who owns the intellectual property, between, if you're creating a business, who's going to get to walk away with it, it's really important. If you have a business partner and you have, like, let's say a trademark, if you decide to dissolve the partnership, who get the rights to that trademark? Your business partner get it, or do you get it? So those are the things you want to think about when you are creating these things. And again, because of the timing, we don't have time to really go in depth on this, but there's a couple of videos on this on my YouTube, and also on my LinkedIn. I have some articles on these topics. And that's it.
You did a great job. I love how concerned you were with getting into that time, right? We're gonna get there in that amount of time, and we have 1 minute to spare.
it's an attorney thing, you know, you have to fix the timing.
Okay. When you charge 800 and something dollars an hour, I get it. It's timing is you think about time, right?
It's like how it works.
Mhm. So thank you so much, Gayani. That was just
No
a
problem.
wonderful, wonderful workshop. And I love that you gave the YouTube links. When you were saying that you had a 3-hour workshop about this, I was thinking, you know, I've actually gone and taken a class when I was in graduate school. I've taken a class in this. So we could talk about this forever, right? There
Exactly.
so much to know. So, but this was a really good introduction to the topic, and I think we'll get a lot of people, you know, started, and they'll know where to go from there.
Yeah, that's what I think the key is to at least be aware of some of the pitfalls. So at least you know where to look for resources. And one thing I would share with you is that I know like intellectual property attorneys and business law attorneys, those are very expensive. If you're going to work with the attorney, you want to know how the attorneys are charging, because when I was at law firms, we were charging every 6 minutes. Every 6 minutes is considered 0.1. So if you send me an email and I respond to the email, that's 2.2. So it's 0.2 times your billable rate. Let's say it's 500 for an hour. You get an invoice for that after the end of the month, you know, because you send an email asking questions. So you want to make sure how the attorneys charge, because not everybody's aware. There are, you know, attorney like clinics that do things like USD law, Thomas Jefferson Law, Cal Western have clinics that help people with some of these for lower cost, and they, you know, so it's not completely inaccessible.
And we have here. I'm sorry, I didn't interrupt. I was just
no. I was just going to say you need to meet certain criteria with financial, like show that you cannot afford an actual, like going to, but there are availability. You want to be mindful of those. And if you're looking for something like that and you're not sure, you could always send me an email. I'm happy to like direct you.
And we have them, Gayani, we actually have resources here that they can access for free. So that's why I was, so I wanted to stop you before they got charged for that message they sent to you. But no, we do have resources here that
that's good.
Yeah, that they can access the attorney fees, and it saves so much, right? It's so much. So if you would like to find out more about that, definitely reach out. We have some people who have some quick questions for you. Ahmad, he wanted to know about fair use. Can you comment on, I'm sorry, I'm not quite understanding your question, Ahmad, commenting on oh, comfortable, I think is a misspelling. Do you want to just go ahead and mute yourself and ask what you were going to ask, Ahmad?
Yeah, kind of give me a context what you're trying to ask so that I could better address it.
Yeah, this is Ahmad. Can you hear me?
Yes, we can.
Perfect. For example, this is going to be a kind of quick, long example, but I did some content on YouTube using an intro of a song. Like I used, for example, 10 seconds, and I put it on loop. But everything in the video was original. It was like my lyrics. I was doing a parody, if that makes sense. I did my lyrics, I did the acting, I did everything visual. And they claimed the video, and I did dispute, and at the end I won that. But for example, on the future, how do I know? I don't want to go through that again. Like, is it the amount? Is it like, what should I do so I can be comfortable using the fair use for other stuff? Does that make any sense?
Yes.
Yeah, so the fair use is a little bit challenging, like I said, to use as a defense, because fair use it's not a fixed standard. So it's and YouTube and any other platform, they tend to be very conservative just because of the intellectual property rights involved, and their best recourse is to take down the video, that to try to help you, say like what you said, you created all that content, you did it by your voice. It's that they might be, what they're doing is they're also using AI to recognize certain patterns. So if you're still, even if you're originally creating it, AI recognize the pattern, the music pattern or whatever, that could still be considered part of what they're recognizing as a violation. So that's why they will take it apart. Now, fair use, again, like I said, it's a kind of an arbitrary standard. So it's kind of difficult to say what will be fair, like you wouldn't get in trouble. Like, less you use the original content, the better. And it's kind of a very delicate balance, I would say, because it's the thing is, you could get accused of it from anybody, right? So that's the other part to it. Even if you only use 10% from something like a movie, that could still be considered enough to be outside of fair use if somebody see it as a problem.
So that was really helpful. That was really helpful. Thank you very much.
No problem.
So I did want to jump in here and just make a little housekeeping note. I saw that so Emma had shared a form with you, and I think Emma has shared it again. The second one that she shared is the correct one. That's our survey. And in fact, I'll go ahead and post this again or it was Brennan, I believe, that shared it. Basically, this is a link to our survey, and we would love to get some feedback from you, so you can make comments to Gayani, to us at the REC, and make sure that we're doing everything that you're looking for. And I know this was such a helpful workshop for me, so I'm sure that they'll have great comments in there. And then there was another thing that I wanted to do. I wanted to ask is if everybody wouldn't mind, I'd love to take a picture together of everyone. And so would everyone mind just turning on their cameras and just smiling? And we'll do a photo here together so we can commemorate our time together. And awesome. So we'll give it just a minute or two for everybody to get their cameras up and running. And a couple more people. All right, and then I'll get us here at the front first. And 1, 2, 3, smile. One more. Just make sure I did it right. And 3, 2, 1, cheese. Great, wonderful. Thank you so much. And I think we'll just, at this point, I don't know if we have a lot of time for some questions. So Gayani, I know we have your contact information. If they did have a specific question, would it be okay then for them to send you an email? Okay, wonderful. Then I'll share
Absolutely.
that.
And if anybody is thinking about law school or anything, they want to chat with me, I'm happy to chat. I mentor people. So, you know, if you have any other question and you're trying to figure out kind of attorney you need to connect with, you could send me an email too. I don't mind quickly connecting you with somebody or resource. So, you know, I do have a lot of content on my YouTube and my LinkedIn. I don't add people I don't know to my LinkedIn, but if you tell me that you saw me at this workshop and you're part of the REC program, I will add you. Otherwise, you could always follow me too on LinkedIn. So just, I'm putting out content there, and that's how, and my model for my law offices, I do flat rate services, so project rates, but not many attorneys do that. So if you don't qualify for one of those clinics or what your resources have, you might be able to find attorneys like me who have this kind of, but you may have to talk with somebody because it's always, you know, we know each other sometimes and not everybody know who's out there. So.
Thank you so much. Yeah, absolutely. Absolutely. So is there anything else you want to take us out with? Any other comments, Gayani, you want to leave us with as we end the workshop today?
No, if anybody else have questions, I'm happy to answer them. I have a few more minutes.
Wonderful. So thank you all for coming. I'm going to go ahead and stop the recording. Thank you all for being here. And then we will keep the Zoom room running if anybody does have any one-on-one questions that they'd like to ask. But thank you all for coming and for being here, especially to you, Gayani. Thank you.